So, last lecture for the semester. Can't believe it's already December, isn't it? Start counting to March and April. But I think we've made good progress, haven't we? I hope so. You know, I always think that syndicated loans is what I call kindergarten or nursery law of financial markets. We're now getting into secondary school, which is bonds. After that, we'll get into the hard stuff. But for the moment, let's stay with what we've been looking at. I'm actually going to walk you through some serious legal work today. It's some of you might find it seriously boring as well, but I'm afraid that can't be helped. We do actually have to look at law sometimes. Hang on, what is wrong with this thing? So how many of you actually remembered to download a copy of the diagram? Fantastic, 2 of you. All right, let me ask the question the other way around. Who hasn't got one? All of you got it, or you're not listening and can't be bothered answering? Which is the question? Never mind. You know, these lecture capture things must have a real collection of stuff on it, isn't it? Like I ask a question, no answer, silence. Then I make a comment and then it's ignored again, and so on and so forth. So it'll be a record for what goes on in these classes. What was I doing last week? I was walking you through, oh dear, what's wrong with this thing? The way that modern bond markets actually work, and the way that bonds are issued, and I think I got you through to the point that we were looking at, hang on, let me just try and get to where we were. Okay, I walked you through basics of international bonds. I think what I'd like you to take away before you go home for Christmas and the turkey, or whatever it is you eat down and for Christmas, is this: that in the modern international bond markets, there are no bits of paper. That's the fundamental break you need to make in your mind from what you would have studied at law school, negotiable instruments, bills of exchange, all that kind of stuff, and how this market works. It works on a completely dematerialized basis, meaning there are no bits of paper. All the trading in the bonds in the markets, which, if you remember, is a massive market, all takes place on the basis of electronic book entries. And the way the market works, there are 3 international clearance systems: Euroclear, Clearstream, and the Depository Trust Company of New York, DTC, which are at the very heart of the whole market. When bonds are issued in dematerialized form, they are lodged with the clearance systems and credited to the accounts of account holders in the clearance systems. Remember that bit. Next, you need to remember that nobody can buy an international bond when it's issued into the markets unless they have one of these accounts in the clearance systems. So if you don't have an account in the clearance system, you meaning a company, a bank, whoever, you cannot buy international bonds when they are first issued. You can buy it later from one of the account holders in the clearance system, but you can't buy it directly. Now, what happens after they are credited into these clearance into the clearance system is that they are traded either between members of the clearance system within this pink box, or by account holders in the clearance system and investors outside. The investors outside could actually themselves be investment banks and dealers, insurance companies, pension funds and the like, or central banks. But they're outside the clearance system. So when they buy bonds, they're buying from account holders in the clearance system or someone who has bought from them. So you can have a Goldman Sachs selling to a Hong Kong-based bond dealer who then sells to a Singaporean bank or the Singapore Central Bank for that matter. That's the chain of sales that you're looking at down here. And that creates a question for us as lawyers. Exactly what is happening in these markets as a matter of legal analysis. The old analysis that was used before the 1960s or maybe even the 1970s, based on the concept of a physical financial instrument which had physical existence and which was called a negotiable instrument under the applicable laws in many law systems, can no longer be applied to this structure, simply because the piece of paper which could be called a negotiable instrument and was called so for 200 years before 1965-70 is gone, doesn't exist anymore. So what we've got to work out is exactly what is being traded, what are the rights of people in the clearance system who are account holders, and even more importantly, what are the rights of second tier, third tier, fourth tier, fifth tier, sixth tier buyers of these bonds during the trading in the international markets. Yeah.
I have a question that is too simple, but I just want to ask you about when they issue the bond and this account holders buy it, then they resell it, they add price, yes? I understand.
You mean what price to this?
Yeah, so basically, if they hold it, it's something about price changing for the issuer when this reselling happens?
Well, I haven't yet talked about price, and I will talk about the pricing of bonds. What I'd like you to do is just to get these basics down, and then we can talk about the issue process. And in the issue process, one of the things that we need to concentrate on is the issue price of the bonds. The fact of the matter is that bonds actually have not one price, but three. There is a price at which they are issued, the price that they have in the markets at any given point in time, and finally, the redemption price, i.e. the price at which, at the end of their life, they are redeemed by the issuer. So there are three prices. I'll come to that shortly. But let's first try and get these basics right about dematerialization. Yeah?
You mentioned that the tier 2 investors' bonds is within the prime capital. What about like the tier
Can I just finish the basics so that we can then get that right first in our minds, and then can we move on from there? Just let's get the basics down, okay? And then we can talk about everything else. So, once we understand that we don't have a negotiable instrument, we need to get away completely from the pre-1970s analysis of bond instruments. It simply doesn't apply in these markets. Now, you might say, well, hang on, in some cases, aren't there definitives printed, actual bits of paper? Yes. In a very small number, 5% or so of international bond issues, for commercial reasons associated with certain investors in certain parts of the world, bonds are actually printed, like the ones that they used to print 40 years ago. But even in those situations, the printed bonds are never distributed. They are lodged with a common depository bank for the clearance systems. And the Common Depository Bank puts these nicely, beautifully printed notes into their vault and just leave it there until the bonds reach maturity by the end of their period of existence. And during that period, from issue to maturity, what happens? The trading occurs exactly the way as in a dematerialized issue. There is absolutely no difference. The bonds are there in a vault. The trading is by reference to fungible amounts of securities. Fungible amounts are credited on day one to the accounts of account holders, and then the trading from the clearance systems out into the outside market, second tier, third tier, fourth tier investors, occurs exactly the same way as if there was a dematerialized issue. So the legal analysis that we have to think about is exactly the same whether you're looking at a dematerialized issue or whether you're looking at an issue which we call immobilized, because notes or bonds are printed and then immobilized in a vault and never distributed. The only other piece of paper that comes out in an international bond issue is the permanent global bond. That is a single piece of paper signed by the directors of the issue if it's a corporate entity and by a central bank if it's a sovereign state, acknowledging and accepting liability for all of the bonds issued in dematerialized form. So it'll be a single piece of paper saying fiat bonds due 2035, value $1.2 billion, due and payable with interest. That's it. The next thing that you might want to ask in your mind is, well, we keep on talking about bonds being issued. We keep on talking about dematerialized bonds. Quite apart from what is their legal nature, they do contain terms and conditions. And the next question that crosses your mind is, where do I find these terms and conditions? If the piece of paper does not exist, where are these terms and conditions to be found? Those terms and conditions of the bond instrument, be it the interest rate, be it maturity date, be it negative pledge clauses, cross-default clauses, whatever it is that you're looking for in terms of terms and conditions, is to be found in a pro forma bond, which is attached to the prospectus in relation to the bond issue, and secondly, to the subscription agreement. Both the subscription agreement and the prospectus I will talk about in detail, but just remember that's where you look for if you're looking for what are the terms and conditions of the bond instrument. So those are the basics. A couple of other basics you need to remember is that bonds are always listed on a stock exchange. But even more importantly to remember, they are never traded on that stock exchange the way that shares which are listed on a stock exchange are traded on that stock exchange. They are traded on ICMA screens, International Capital Markets Association authorized screens, usually Bloomberg, Telerate, or Reuters screens, which are on the desks of every bond trader in the markets. That's how they are traded, and that's where if you want to find a price, you'll find the price on an ICMA, ICMA screen, not on a stock exchange. So there is a disconnect between listing and trading. And if you ask the next question, why is that happening? Why are we doing it this way? The answer is very straightforward. International investors don't want to buy securities which are not listed and therefore regulated by a recognized stock exchange. So unless they're listed, you're not going to get too many investors. You won't find any investors. So therefore, it needs to be listed. But the trading is done elsewhere by the Bond Traders Association, which now is called the International Capital Markets Association. So the listing is done for investment purposes and for purposes of assuring investors that this bond has been looked at and regulated by a recognized stock exchange. And that takes you on to another aspect of these international bond issues. The prospectus which I just spoke about is the basis on which the bonds are actually listed on a stock exchange. They are listed on the basis of a prospectus which complies with regulatory law. What that regulatory law is, we'll come to that shortly. But that's the stamp of a good bond, if you want to put it that way, which a stock exchange gives on the basis of a prospectus approved by the stock exchange. So that's why we have this format in terms of the way that bonds are traded and issued and held in dematerialized form. Now, you come back to the law, you then have to ask, well, what is the nature of these documents that are being issued? The permanent global bond is the only, as I said, the only legal instrument representing the totality of the bond issue. Now, without a doubt, that permanent global bond is a debt instrument. Exactly the same way as a syndicated loan agreement, an SLA is a debt instrument. It is something on the basis of which a borrower of funds or an issuer of bonds can be held liable legally under applicable law, under the governing law. But beyond that, one cannot go because that's the only piece of paper there is. And so if you want to bring a legal claim against the issuer of a bond, that's the piece of paper you need. That's the basis of the legal claim against the issuer. The dematerialized bonds credited to the accounts of account holders in the clearance system are not a debt instrument and cannot, at law, give rise to a legal claim against the issuer. And that's a fundamental. This is a trading mechanism. Dematerialization, credit to the accounts of account holders, trades that you're looking, oh, I lost my diagram again. The tier 1, tier 2, tier 3 sales are trading. They do not confer rights against the issuer. The only rights that can be claimed against the issuer are contained in that permanent global bond. Now, I mentioned earlier that one other feature of the market that you need to remember is that although I keep talking all the time about a permanent global bond, there's also something called a temporary global bond which is issued in the markets. That is done due to the requirements of United States securities laws, which we will have to come to in great detail very shortly. If US law demands the issue of a temporary global bond, not a permanent global bond, the markets will comply regardless of whether it's in Tokyo, London, Singapore, Hong Kong, or New York. The temporary global bond structure, therefore, is one driven by, demanded by United States securities law. When a temporary global bond is issued, it is valid and effective for a short period of time, usually 40 days, at the end of which a permanent global bond is issued. But we'll come to that bit much later. I just mention it in passing so you remember that there are two types of global bonds, permanent and temporary. Right. Let's move on from there. Okay. We're now trying to work out the question I started off with last week. What is the legal analysis that we apply to the structure that we've just been talking about? It's not an easy answer. It is complex. But I think I've summarized this last week in that format, that this is the generally accepted legal analysis, not amongst anybody else other than the global law firms, and they're the only ones who matter in this market. What most global law firms, I see all global law firms agree, is that what is being traded in the market is not a bond at all. There's no bond. There's no piece of paper. What is being traded in the markets is a bundle of rights in respect of either the permanent global bond, where the structure is dematerialized, or a bundle of legal rights in relation to the immobilized securities, where an immobilized structure and definitives are being used. Now, what bundle of rights are we talking about? Where does it come from? Well, the bundle of rights, obviously, there are rights arising between the issuer of the bond and the account holders in the clearance systems to start with, based upon the terms and conditions of the bond instrument. Where do you find that? As I said, in the prospectus or as an appendix to the subscription agreement. Those are the terms and conditions of the bonds. In addition to that are the rules and regulations of the international clearance systems, where the bonds, the dematerialized bonds, are credited into the accounts of account holders in the clearance systems. So you're looking at the law systems of Belgium in relation to Euroclear, Luxembourg in relation to Clearstream, and New York law in relation to DTC. Three law systems now overlay the regime of rights being created in relation to quote-unquote the bonds and constitute and are part of the bundle of rights that we are talking about. So they are, in a sense, a combination of two sets of terms and conditions. The terms and conditions in the actual bond instrument under the governing law of the bond instrument, and secondly, the law applicable by the law of the place where the clearance system is located, and in practice that would be Euroclear in Belgium, Clearstream in Luxembourg, and DTC in New York. So the bundle of rights that emanates stems from those two sources. Those are the rights, the bundle, that is passed down in the chain of sales. Not a bond. There is no bond. Now that is the accepted analysis, but I hasten to add that we need to give it a little bit more flesh and blood, because you need to look first at the account holders, what are their rights, and then what are the rights of the second tier, third tier, fourth tier investors in bonds. Now, the account holders in the clearance systems, the ICSDs, have contractual rights based on the bond instrument, because that's credited to their account when the bonds are issued. So the relationship of debtor and creditor exists between account holders who have been credited with bonds into their accounts. They are the creditors in relation to the issuer, who's then the debtor on the bonds that have been issued. But don't forget, there is nothing specific that each bondholder, account holder, no, I shouldn't use the word bondholder, account holder has in relation to the bonds. All it has is a right to a fungible amount of the bonds. Why? Because the bonds are held only on a fungible basis, on millions of dollars. $5 million fiat bonds credited to the account of Goldman Sachs at Euroclear in Belgium. So it has a right to a fungible amount of securities, not any specific securities, because there aren't any specific securities. If the bonds are actually printed, i.e. because there are definitives, then we are now looking at an immobilized structure, not a dematerialized structure, then the account holders, excuse me, have a right, a legal right, to the delivery of those bonds if they are printed. Then comes the overlay of the law systems of Belgium, Luxembourg, and New York in relation to this structure. Remember that, as I explained to you last week, the Royal Decree of Belgium and the Grand Ducal Decree of Luxembourg and Article 8 of the Uniform Commercial Code in New York, in the US, has a very peculiar feature. It's all common to all three. There are contractual rights that each account holder has in relation to the bonds credited to its account. But unlike in an ordinary insolvency, if there's an insolvency of the clearance system, ordinarily those contractual rights against the clearance system would fall right into the insolvency of the clearance system, and account holders would have no rights except in an insolvency. But all three law systems, Belgium, Luxembourg, and New York, actually provide a transformation of the contractual rights of account holders into proprietary ownership rights in relation to the fungible amounts of securities credited to their accounts in the event of an insolvency of the clearance system. So there's a transformation, excuse me, the transformation of the contractual rights to ensure that the rights of the account holders do not fall into the insolvency of the clearance system if ever that happens. I mean, it'll be a market meltdown if that happens, but we're talking about an extremely unlikely scenario. But in that scenario, the account holders' rights rise above the insolvency because of the laws applicable to the insolvency of the clearance system. That much we're clear about. Next question that we have to think about is, hang on, I think I've dealt with this bit. Yeah. I've dealt with this stuff. Okay. So that's the accepted analysis in the global law firms. Essentially, it is a contractual structure that we are talking about, overlaid by this transformation of the contractual rights into proprietary rights only and only insofar as the account holders and the clearance systems are concerned, and only in the event that the clearance systems go into insolvency. Okay? That's the basic structure. But that's not the only analysis available out there in writing. There's a pile of stuff that's there, and I'm only going to acquaint you with what people have said. They've all been dismissed by the global law firms, and I can explain to you exactly why in a few minutes. The first of the attempts to explain this structure was done by an academic, Benjamin, in a book, Interest in Securities, published in 2001. I don't know whether you want to go read it. I wouldn't recommend that you read it. It's just pretty much past its time in terms of the analysis. But what is argued in that book is that the international bond clearance, holding, and trading structure creates, quote unquote, a pool of fungible assets at the ICSD level. A pool of fungible assets at the clearance system level. And that everyone who buys, quote unquote, bonds is buying an undivided share in this pool of fungible assets within the clearance systems. Now, this analysis is based on purely, and I mean purely and simply, on English domestic law rules in a case called Hunter and Moss. Now, the moment I say that, you'll realize that the entire analysis from page 1 onwards is completely flawed. Why? Because you cannot, even under English law, apply an English law analysis to a multi-jurisdictional structure. Because the moment there is a foreign element in relation to the law applicable, English law itself says you will now apply not English domestic law, but the conflict of laws rules of English law. Now it is, of course, Rome and beyond. But fundamentally, the flaw is that you apply English domestic law to something in relation to which you cannot apply English domestic law under English rules themselves. You need to apply English conflict of laws rules because you've got a multi-jurisdictional structure. So I'm not going to say any more than that. If you want to follow it up, read all about it, please do. And then there is a book, 1996, Professor Good, who wrote in 1996 saying that the entire international bond markets were subject to an English law trust. Luckily, investors didn't read it, because they would have fled if they were told that what they were buying was subject to some kind of common law trust. But that's the argument that he made, saying that everything is subject to an English law trust. And I mean, the obvious answer to that is, well, you don't apply English trust law to something happening in Luxembourg and Belgium and New York, and traded from Singapore to Hong Kong to Brazil to everywhere else. Once again, the flaw is to ignore the multi-jurisdictional aspect of the international bond markets, which then requires, under English law itself, not to apply English law, but to apply English conflict of laws rules. And that's all I'm going to say about Roy Good's book. If you want, please do read it. And again, it's the same criticism. You can't apply English domestic law analysis to a multi-jurisdictional system where the rights arise under different law systems. It just simply doesn't make any sense. Third one. This is a refinement of this trust analysis. Again, this was done by Benjamin, who argued that there is a trust, but the trust only exists at the ICSD level. I think we all sat up and thought, really? An English law trust arising under Belgian law and Luxembourg law? How the hell does that happen? How do you apply, how does an English trust arise under Belgian law and Luxembourg law in relation to securities held within the system? So I don't think we really bothered too much with these three analyses, all of which obviously are academic analyses. But I thought you should know that there are these three analyses, and if any one of you one day wants to write an opinion based on this stuff, welcome. You won't have any clients, but that doesn't matter. The fourth approach to the analysis, which is a bit more sensible, is to say we need to look at the lex situs. We're back to that one. The lex situs to decide the nature of the interests of bond investors and what is being traded. And that's a fair point, because the general conflict of laws rule, as you well know, is that the law applicable to intangible assets is the lex situs of the asset. The problem, of course, is where the heck is the situs of the asset? Now, there's an entire book, which I haven't actually asked you to read, which tries to work out what is the situs of international bonds. And there are a whole number of possibilities, and that kind of makes the analysis of little value. The situs in a multi-tiered holding structure could be as follows. And I'm afraid we're going to use Latin. That's because when we can't say something in English or French or German, we switch to Latin. So apologies for the Latin usage. But first one, it's the place of incorporation of the issuer, the lex incorporationis, and the res, i.e. the thing, once again Latin, which is being traded in a multi-tiered holding structure is not the bond, but the rights created under the system of the international clearance systems. But it's a bit odd, because bond issues will, when we move on the road of bonds, you'll find are issued for purposes of tax and convenience from places like the Cayman Islands. So if this analysis is right, the lex incorporationis could be the Cayman Islands, could be Nassau, could be any place that is picked for tax and other reasons, which doesn't make a lot of practical sense. But at least that has some element of solidity about it. You're saying, let's look at the place of incorporation of the issuer. But then again, if it's an Italian bond issue, which is now being traded in Hong Kong, sold to Japanese investors, you ask the question, why are we applying Italian law to a sale between a Hong Kong seller and a Japanese buyer? So while it sounds reasonable, once you start looking at the detail, you realize that it doesn't really make sense to apply the law system of the issuer in relation to trades occurring which have nothing to do with the place of incorporation of the issuer. The second situs that people have talked about is the place of the register of the securities. Now that, in relation to immobilized and dematerialized securities, is very straightforward. The place of the register of the electronic books is the place where Euroclear in Belgium, or Clearstream in Luxembourg, or DTC is located. So The argument here is that that is the law which needs to be applied to understanding bond trading. But I come back to the same question when we look at this. Why should Luxembourg law or Belgian law be applied to a bond trade occurring between a Hong Kong seller and a Japanese buyer? It has absolutely no practical sense to do it that way. And don't forget that in relation to that sale between the Hong Kong seller and the Japanese buyer, there's a sale document. And guess what? Every sale document in practice has a governing law. What this analysis suggests is that we throw that all away and say, so we apply Belgian law and Luxembourg law. Again, something that doesn't commend itself to most people who've looked at this. Then we've got the third one, which is the lex situs cartae, which is the place where the physical instrument is located. Now, if you ask that question, well, where is the physical instrument located? It is where the permanent global bond is physically held by the depository bank. Or if there are definitives, where those definitives are to be located, usually in the vaults of the depository bank. That is simply a matter of convenience. You could have a bond issue out of Singapore or an Italian issuer where the bonds are held in definitive form or in permanent global form with a depository bank in London. Question, why are we applying the law of the place where the physical instruments are located, namely London and English law, to something happening out in Singapore or in Brazil? Once again, it doesn't make a lot of practical sense to adopt these philosophical principles and apply them as is. Then we have the next possible option, the so-called lex loci actus, i.e. where is the law of the place where the transaction of purchase and sale is being effected. So if in my example, Italian bonds, Hong Kong seller, Japanese buyer, you would look at the place where the transaction was effected between the Hong Kong seller and the Japanese buyer. And that would be the place where the law of the place which would determine the nature of what is being sold and what is being traded. So in our example, the sale would occur at the place of sale, namely in Hong Kong, the Hong Kong seller selling to a Japanese buyer. So Hong Kong law would control that sale. But if the Japanese buyer then on-sells the bond to a New York buyer, Japanese law would now control the sale between the Japanese seller and the New York buyer. Once again, you've got to ask, does that produce a practically sensible result? Sometimes it does. And I think the lex loci actus is something that people will say, yes, that makes some sense. Then we have the lex loci contractus, the place where the transfer of the interest in securities held in electronic form is sold under a contractual document, and the law applicable is the law where the contract is entered into. Again, not very dissimilar to the lex loci actus, and again has some element of common sense and rationality to using that. The next one is the lex creationis of the shows or interest in immobilized or dematerialized securities, meaning the law of the place which creates the rights in relation to the immobilized securities or the dematerialized securities. What would that be in practice? The straight answer is easy, because that right is being created on the electronic books of the international clearance systems in Luxembourg, Belgium, or New York. But then again, while that is perfectly acceptable in relation to the first sale, the question then is, well, why should the sale between the Hong Kong seller and the Japanese buyer be subject to the lex creationis, i.e. the law of the clearance systems in Belgium or Luxembourg? So Luxembourg law or Belgian law would now control a sale between a Hong Kong seller and a Japanese buyer. Does that make sense? So as you probably realize by now, all of these analyses on the lex situs, although it has got some attraction, doesn't fully make sense in all the situations we can think about. Then we look at the position under English common law, because there's case law on this in 1996. And the English courts said, yes, it is the lex situs which needs to be applied. Then after that, what is the lex situs? They had not a clue. They had about 18 different solutions in relation to what is the lex situs. Something like Brexit. Parliament has got 16 different ways, and as you know, we're having a serious comedy drama this evening. That's why I got late. There's a lot of traffic. I guess everybody's going to Parliament to see the latest act in the comedy. Anyway, to come back. In Bishopsgate investments, the High Court judges and the Court of Appeal judges simply couldn't agree. There was no majority for any particular view of what is the lex situs, and that's why I said it looks like Brexit. Therefore, that case, the leading case, is obviously not of much use to anybody to trying to decide this matter. Next, let's look at what happens in the US, see whether we can get a solution out of that. Now, Article 8 to the UCC is a very interesting article. It talks about a legal concept, which is new. It's called a security entitlement, to define the relationship between the holder of the entitlement. Note the word entitlement, not a bond, not a security, but an entitlement, and the securities intermediary, i.e. the seller, the dealer, in relation to the sale of these, lack of a better word, electronic instruments. Security entitlement is defined in Article 8 as a bundle of rights. Here's that wonderful phrase, bundle of rights. That's where we all get it from. Exercisable against the intermediary, i.e. the dealer who sells, and not third parties, except when the intermediary becomes insolvent. Where does that strike a chord? Yes, it's the same rule in Belgium and Luxembourg under the Belgian Royal Decree and the Luxembourg Grand Ducal Decree. Contractual rights to fungible securities except if the clearance system goes into insolvency. That's the Article 8 rule as well. So, under Article 8, yes, there are rights in relation to a security entitlement in the buyer of this security entitlement from an intermediary, i.e. a dealer. But they are contractual rights until the clearance system goes into insolvency, at which point they convert into proprietary rights. But again, just like in Euroclear, just like in Clearstream in Belgium and Luxembourg, it's a bundle of rights in relation to fungible securities. There is no right to any particular security. Exactly the same as the two law systems. Now, question. This works perfectly within the United States in a domestic context. Article 8 is the basis of the law in every state in the US. Question is, can you actually use this outside the US? Well, as a model, it makes sense. But the problem is, how does the law actually dictate such a conclusion? Because if you've got bonds of a Brazilian company held with DTC in New York, and account holders sell these entitlements, in the language of Article 8, to an Italian dealer who then sells to a Japanese financial institution, do we still continue to apply Article 8 UCC? Do we say Japanese and Italian law in relation to the sale, and Japanese law and Italian law, if it is the contractual law of the document of sale, do we say that's completely irrelevant? Well, the straight answer is you can't. Consequently, the way I think most of us practicing in the markets would look at this is to say, Article 8 of the UCC is a good model. It is perhaps the best model in relation to the analysis of the holding of entitlements to securities held in a clearance system and their trading thereafter outside the clearance systems. It's a good model. But how do we apply it across the board, across the globe? Because there is no convention, no treaty. But it's a basis for the legal analysis which I've just explained to you as the one that I think most global law firms accept. That what is being traded is a bundle of rights. In US terminology, a securities entitlement. And that is contractual. It's not proprietary. There are no trusts, no fungible pools of assets, just contractual rights that are traded down from one seller to the next. Now, what happens in the EU? Well, we got nothing to compare with Article 8, unfortunately. What we've got is an awful, and I mean awful, patchwork of directives that, I'm sorry, you had a question, didn't you? Have I gone past it now? Oh, okay. A patchwork of directives and regulations which indirectly, and I use this word very carefully, indirectly affect the question we are looking at. What's created, what's being sold, what's being traded? That question is indirectly affected by a number of EU directives and regulations. I don't think I want to take you through it line by line, but just to acquaint you with what these are so that you're familiar with what might be relevant to an analysis. There is, first of all, Article 8 and 9 of the Settlement Finality Directive. You've got the formal title, Article 8 and 9 of Directive 98/26 EC. Now, interestingly, this directive deals only where securities are held within an international clearance system. In the jargon of the EU directives, they are called Central Securities Depositories, or CSDs. Nobody uses CSDs. We all call them International Clearance Systems, ICSDs. But the rule that is being applied in these under Article 8 is this, that where you've got any insolvency proceeding in relation to a member of one of these clearance systems, their rights and obligations are not governed by ordinary EU insolvency law, but by the law governing the clearance system. In other words, under Article 8, the law of the clearance system overrides. Why is that important? Because it gives primacy. Primacy over everything else. The law of the place where the clearance system is functioning, operating. And that's an important indicator of where we ought to be going in our analysis. And then there is Article 9, which deals with a collateral provided by participants in a clearance system, either to the clearance system or to the European Central Bank or other central banks. Article 9 provides that the rights in relation to the collateral will be determined by the law of the place where the clearance system is located. Again, the finger is pointing hard at the law of the location of the clearance system in terms of analyzing what's happening in the markets. But it's simply an indicator. It does not deal with the question we are talking about. Somebody had a question? No? Okay. So the choice of law rules in Article 8 and Article 9 of the Finality Directive point very clearly to the law applicable in relation to the clearance systems. Okay, so that means you're looking at the law of Belgium and Luxembourg in relation to securities held within the clearance systems. But these two provisions do not, repeat, deal with what rights and what law determines the rights of investors buying bonds outside the clearance systems. What it deals with is Tier 1, that you would apply, and you should be thinking about the law of the place where the clearance system is located. Oops, sorry. Then we've got Article 9 of the Insolvency Regulation. Again, it doesn't deal directly with the question we are looking at, but it has a rule which says the effect of insolvency proceedings on the rights and obligations of the parties to a clearance system. Rights and obligations in relation to insolvency proceedings. On the rights and obligations of parties to a payment or settlement system shall be governed by the law of the member state applicable to that system or market, i.e. Belgian law or Luxembourg law, if it's Clearstream or Euroclear. Now, why is that important? Because the insolvency regulation of the EU actually applies in an insolvency the law of the state in which a corporate entity has its center of management and control. That should be the law which is being applied, but Article 9 overrides that rule and says, no, 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 look at the law which controls the clearance system in relation to a party who is a member of that clearance system. But this is a very limited rule, and I think it's important not to draw too much from it. But again, it is pointing, as far as EU law is concerned, to the law of the place where the clearance system is located. Still not conclusive. I'm not going to go into the directive on reorganization of credit institutions, but I want to talk about this one. This is usually called the Collateral Directive, otherwise known as the Directive 202/47/EC on financial collateral arrangements. What it does is it provides a choice of law rule within the EU in relation to, here's the important bit, book entry securities collateral. And what exactly is a book entry securities collateral? Defined in Article 10. Financial collateral provided under a financial collateral arrangement which consists of financial instruments, important words, title to which is evidenced by entries in a register or account maintained by or on behalf of an intermediary, like a securities dealer, broker, or bank. And that means this provision applies to securities in accounts held electronically within clearance systems. But before we draw too many conclusions, this choice of law rule applies only to collateral, meaning something held as a security interest, an asset held as a security interest. But in relation to such assets, what the Collateral Directive says in Article 9 is a conflict of laws rule, which is extremely important. It says that the law applicable is the law of the place of the relevant intermediary. In other words, the place where the electronic books are located. This is much wider than the Finality Directive. Why? Because Article 9 refers to all book entry collateral, i.e. not simply securities held within the clearance systems. And that's an extremely important indicator of which way EU law is going. It applies to any intermediary which holds securities on their electronic books. And what this directive does in Article 9, Article 9.1, is to say what law determines the rights in relation to such collateral, now note it's only in relation to collateral, is the law applicable to the electronic books of the intermediary. Not just, obviously it will apply to Luxembourg, Clearstream, Euroclear, Belgium, DTC, New York, but also any other intermediary where securities are being held on an electronic basis. Now, let me just take you back to something which I wanted to draw to your attention, and that is the diagram. Now, if you look at this diagram and apply Article 9 of the Collateral Directive, it applies there, clearly, But importantly, it applies here, it applies there, it applies all the way down. Because each one is an intermediary which is holding, quote unquote, electronically on its books securities accounts. And the collateral directive says, as far as the EU is concerned, we will apply the law of the place of this intermediary. So in my previous example, Hong Kong seller, Japanese buyer, the EU directive says, look at the law of the place where the Hong Kong seller is selling and where the securities entitlements are held, Hong Kong. Equally, if you're looking at a sale by a Japanese seller selling to a buyer in San Francisco, you'd look at Japanese law under this directive. Yeah? Sorry, I'm missing the word. There is no ultimate owner in this structure.
You are the last one in the chain.
The lower.
Yeah, the lowest in the chain.
Yeah?
You are not the intermediary is the one above.
Exactly. I mean, the phrase intermediary really refers to dealers who are buying and selling. So if you've got an end buyer, like an investment fund or indeed a retail investor, that's not an intermediary. What you'll be looking at in this sale is the law applicable to the fund manager here, which sells to an investment fund. Or if you're looking here, a bank which sells to a retail investor, you're looking at the electronic books of the bank. That's the law applicable. So in my sale of the Hong Kong bank selling to a Japanese financial institution, it's the Hong Kong bank. And if the Japanese financial institution now on-sells to a buyer in San Francisco, you would apply Japanese law to their transaction. That's what the EU directive is suggesting. Now, if you go back to Article 8 of the UCC, that is exactly the same structure that Article 8 uses. Now you can see why the global law firms have said the consensus view is that we look at each tier as the place where we need to look at what are the rights being sold. There isn't one simple rule across the board other than look at the place where the books are of the seller. That's the law which you need to apply to determine rights, obligations, and what is being transferred. Somebody raised a hand up somewhere down here. I missed it. No? Okay. This is not an easy one. That's why I said I'm going to walk you through some pretty hairy territory, legal territory. But that's where it is, and unfortunately, if we come to a conclusion, it is based on looking at US law, looking at EU law, and looking at general principles in the conflict laws like Lex Citus, and then coming up with an analysis which attempts somehow to explain what is happening legally in relation to the trading of securities. Now, finally, and I'm not going to go through this, an attempt was made in the early 21st century to try and find a resolution across the globe for what is happening in the global bond markets. After all, a $51 trillion market, you need some kind of certainty. So there we go. Everybody got together, and inevitably, like all these wretched conventions, I don't know why, they end up in The Hague, in the Netherlands. And inevitably, they drafted a convention, and inevitably, like all the ruddy conventions are coming out of The Hague, they are a useless compromise between civil law requirements and common law requirements. So it was published in 2003. And guess who signed it to date? Mauritius and Switzerland. So the Hague Convention will die the usual death of most Hague Conventions. Nobody signs them. So I'm not going to walk you through it, but if you like to, just go through it. But it does contain, and the only reason I mention this is that quite apart from the detailed rules which everybody is unhappy with, it does, however, contain a very important principle. And it is that one should be looking at the law of the place of the intermediary. And that law should control the rights and obligations of the parties and what is being traded at each tier. Therefore, the Hague Convention, in a sense, at least in principle, reflects exactly the result in the Collateral Directive and Article 8 of UCC. And so, ultimately, that's why the global law firms have come to the conclusion that what we're saying is we apply the law of the place where the ICSD is located in relation to the first sale and the definition of what is actually being traded, the securities entitlement or the bundle of rights. Thereafter, we look at the electronic books of each intermediary making the sale and apply the law applicable to that intermediary making the sale. That's the analysis that we've come to, but you come to that through this really convoluted, complex way that I've tried to explain to you in summary form. And if it's not clear to you, don't worry, it's not clear to most people. Okay, now, I'm sure there's going to be hundreds of questions, and yes, of course, starting with you. Where to end, I know. Join the club. What in particular do you want to understand? I mean, I think if you go back to the point at which I started, okay? I said to understand what's going on in this diagram, what is being traded, what law applies, I said that the accepted analysis is, where are we? Yeah, that, which is what I've just told you as the end summary of where we are. You look at the law systems of the ICSDs, Belgium for Euroclear, Clearstream, Luxembourg, and DTC, New York, as the starting point of what is being created. Because nothing printed, all that's happening is something electronic is being credited at the level of the ICSDs. So we have to pay attention to exactly those law systems to work out what it is that's being created. And then they are sold down the chain of sales, something. What is being sold? Answer, it's a bundle of rights. Why are we coming to that conclusion about bundles of rights? Because that's the concept we borrowed from Article 8 of UCC, because it talks about securities entitlements, but not securities or bonds, just entitlements, rights. No, I think that's the point we talked about earlier. I think the point when you were thinking about dinner or something. I mean, it's a very good model, but it can't be used because you'll be applying the law in the UCC for trades between your Hong Kong seller and your Japanese buyer, and your Japanese buyer and your Russian buyer. You can't. I mean, it doesn't make sense to apply US UCC law to those two trades, which have nothing to do with the US, and there would also be a governing law in relation to each of those trades in the contractual documentation. So to that extent, you can't. But in effect, the analysis that we just talked about actually uses exactly that concept, that there is a securities entitlement or a bundle of rights which is being sold by A to B to C to D in that chain of sales. What law controls each one depends on the electronic books of the intermediary or seller. That comes out of the EU Collateral Directive and the Hague Convention saying, look at the law of the place where the electronic books are held. So you start with the ICSDs, Belgium, Euroclear, DTC, and then you go on to the second-tier sellers. If that's a Hong Kong seller, you look at Hong Kong law for that sale, and if the next sale is Japanese seller selling to a Russian buyer, you look at Japanese law, and if the Russian buyer now sells to a German buyer, you then will apply Russian law to that sale. That's the analysis that we've all come out with, and it's a combination of UCC Article 8, very broadly a lex situs concept, and the EU Finality Directive. And of course the Hague Convention concept of the place of the intermediary as the place determining the rights and obligations. So that's the bottom line. And everything else you can bin. No, you don't do that. Go and read all the wonderful books written on it, which makes absolutely no sense. Yeah, please.
So with regard to the actual bundle of rights, that changes between which intermediary sells.
in one sense, you're right saying it might change. But it is the same bundle which is being sold from A to B to C to D, with the caveat, with the qualification that the law of the intermediary's location, law of Hong Kong, law of Japan, law of Russia, would affect that bundle and what it means. But the minimum rights that are being transferred is that bundle that came out of the clearance systems. It can be amended, qualified by the law applicable at each stage of the sales, by the law applicable to each intermediary. What we've arrived at is a conclusion by analysis. There is nothing which actually says what I've just said to you. It's a conclusion arrived at by analysis, by reference to Article 8 UCC, the Hague Convention rules, and the EU regulations and directives. Right, have I left you sufficiently confused? No? I haven't succeeded? Sorry, your question.
So this is how the convention is only Switzerland and Mauritius. Why should you look at it?
Why should you look at it? It contains a very useful general principle. The general principle used in the Hague Convention is the rule that in order to determine the nature of the rights and what is being transferred, one should be looking at the law of the place of the intermediary and where its electronic books are located. That principle is pretty much the same whether you're looking at the EU Finality Directive or whether you're looking at Article 8 UCC. So to that extent, it's a useful principle. But when you get into the detail of the Hague Convention, it is a worse mess than Brexit. It really is awful. It is a conflict. It's a continuing conflict between trying to reconcile common law rules with civil law principles. And you know what happens when you try to do that. It's a mess. Yeah. So do you have another question? You want to finish your question? I can get on to your colleague.
Okay. So if I'm in Japan,
Yeah.
what law do I use? Because I know that this question...
Who is the you? Again, if I'm in Japan, what law do I use? What are you doing in Japan for a start? Apart from having sushi. All right, so you're a fourth-tier intermediary in Japan. Who are you selling to?
Russia.
Okay, that's good. So the question that you're asking is what law would you apply? Well, first of all, there would be a governing law of that sale to control just the sale, nothing else. What is being sold and what is the bundle of rights will be determined by Japanese law in relation to that sale. Now, that is not the end of the story, because that bundle of rights sold under Japanese law doesn't arise under Japanese law, does it? It arises somewhere else. It arises somewhere up there under Belgian law, Luxembourg law, or New York law for DTC. It's that bundle which is being sold. Secondly, there is this. The terms of the bond instrument itself, which is contained in the bundle of rights which are being sold. So yes, Japanese law, but there are these two other things that you've got to be looking at. Yes, I know it's not a tidy solution, but that's where it is. Would you believe that the global law firms never really sat down around a table and said, let's agree what this is all going to be? We never did. I mean, I personally was saying to people I knew, said, we need to agree this and have a joint opinion. No way. Nobody wanted to sign a joint opinion with regard to exactly what was going on. There was a general agreement, and that's where it is even today. And it's just, we've never really come up with a joint opinion saying this is where it is. But in one sense, that's a good thing, because everybody has got a standard legal opinion about what happens. And people buying bonds from Jakarta to Moscow to Kazakhstan suddenly realize that they're not getting any bonds. And then they ring up their lawyers and say, what have I got? What rights do I have? You press the button and out comes the same opinion, and out it goes, and you get a big charge, meaning fees for that opinion. But it's the same one that goes up, the one I've just given you. But that's because most people, and that's why I started the discussion with you saying, when you talk about a bond, what are you thinking about? And most people, including corporate entities and banks, just think about a bond in a very old-fashioned way, a piece of paper saying, I owe you $5,000 and I will pay an interest rate of 4%. And that simply doesn't exist. So yes, you can write this opinion and charge a lot for it, ongoing, when you start practice. Yes? Yeah, go ahead.
I don't understand how collateral directive apply to the bond.
It doesn't apply. It doesn't apply. Like I said, it only applies to securities entitlements held as collateral. What we are relying on in relation to the collateral finality directive, the Hague Convention and everything else, is a principle that is embedded in the regulation. That's all. Oh, the collateral directive is utterly important, not in bonds, but in derivatives. Because the purpose of the collateral directive, just to give you a one-line answer to that, the purpose of the collateral directive is to ensure that the structures for collateral used in derivatives, which are completely unlike anything else anywhere else, are recognized across the Union. In particular, something called a full transfer of title collateral under English law. Article 9 simply gives effect to that right across the Union. So it's got another function, but the principle it applies is relevant to what we're doing here. Right. Golly, 4:20. Yeah. Very, very good question.
Because even if it's not bonds, if it's a bundle of rights, still you have, it doesn't matter, reading practice. What I think, and the second question is that the opinion you provide is like that qualifying the whole analysis, or is it like a strong statement or something?
Well, you asked me a question, I'll answer that. What is the practical purpose of this analysis? The straight answer is that in relation to the taking of collateral consisting of quote-unquote bonds, billions of dollars of bonds are held by way of collateral by central banks. And who gives them collateral? Banks within their jurisdiction. That collateral consists of quote-unquote bonds. So the first thing is exactly what is it that the European Central Bank or the Federal Reserve Bank in New York, what are they taking collateral over? They're bonds, yes, but bonds? What bonds? So this analysis helps you answer that question. What is it that the banks have got? Secondly, it also helps you answer the question, when you buy a bond, and this is what I call the Brazilian question, when you buy a bond, what on earth am I buying? Do I have rights against the issuer? The answer is no, you don't have any bonds, and no, you have got no rights against the issuer. But to come to that conclusion, that's the analysis you need to go through, to make someone appreciate that what you've got is not a bond, and even more importantly, that you have no rights against the issuer. You only got rights against the intermediary who sold you this thing called the bond, but which is in effect a bundle of rights. Okay, moving on. Anything else? Good. Now, okay. Why don't we? What do we want to put in there? Sorry, what are you proposing? What do we need to be putting into this pro forma bond? There is a choice of law clause. Absolutely. In every bond instrument, there is a choice of law clause. Either English law or New York law, whatever you choose. But the problem is, what does that choice of law control? Answer, the rights between the issuer and whoever can be regarded as the person with rights under that bond instrument. Now the question is, who is that person? If you're a fourth-tier investor, are you that person referred to in the bond instrument? And this whole analysis is to tell you, no, you're not. The relationship of, as I said, creditor and debtor, therefore, exists only between the issuer and the account holder. So the rights contained in the bond instrument and the governing law of the bond instrument would only control those rights. It does not affect second-tier, third-tier, fourth-tier investors, because they are not buying that bond. They are buying a bundle of rights from someone selling something to them, which carries interest and principal.
Can you specify the actors now in the cascade? Can you specify each time what role?
Well, there is one format which might address what you're thinking about, and I haven't yet come to that. In a default scenario, and only in a default scenario, English law firms, global law firms, have developed something called a deed of covenant. I'll come to that under default, but I'll mention it to you now. What the deed of covenant says is that in the event of a default by the issuer, and a default being called in formal manner, a deed of covenant is triggered, which then confers on any investor in the securities entitlements at the time of the default of the issuer to immediately become in possession of contractual rights directly enforceable against the issuer. That is the only type of instrumental structure which produces the result you're thinking about, the deed of covenant structure. I'll come to that when we talk about default. Sorry? You're going well ahead, but the answer to your question is yes. You're way ahead of everybody, but let's come to that later. Right. That's the sort of mess of analysis in relation to what is being traded, what are the rights of everybody down the chain of sales that you've got to work with and deal with as you go along. And that's why we had to go through a pile of rather complex law. Right. Now let's get on to something really easy and simple. Bond issue process. How does it work? Meaning, just the steps. How to get a bond issue off the ground. Now, in that context, I'm going to draw your attention to something called the ICMA recommendations, ICMA recommendations, which are very important in practice. First of all, note, they're not laws, they're not regulations, they have no authority whatsoever from securities markets regulators or anybody else. That's a trade association which has got a set of recommendations. But it might as well be law because everybody follows it to the letter. Now, the way a bond issue works has a lot of similarity with the way that a syndicated loan is put together. First of all, you have got potential lead managers of a bond issue, and there's a bond, and there is a lead manager, and there are co-lead managers, just like in a syndicated loan. They would market a bond to potential issuers, and they would go and talk to issuers about getting a mandate to raise funding on the basis of a bond issue. In order to do that, there's something else that potential prospective lead managers do. They meet with groups of large investors, and they will get soundings, feedback from groups of investors as to the appetite of those investors with regard to a proposed bond offering which the lead manager is going to try and convince an issuer to take. That's obviously reasonably price-sensitive information as to what people are thinking about. Will they buy fiat bonds priced at 4% in dollars, for example? Or would they prefer to buy Mitsubishi bonds denominated in euro at 4%? That kind of pre-mandate investor meetings. Now, it is important that you remember one rule at this point in the process. Information discussed at these meetings might be price sensitive. And therefore, there is a rule contained in the European Union's regulation of March 2014, Article 11, which says that each member of the investor group must be warned that the information that they are being given in the context of the discussions could be price sensitive, and that there should be no transmission of that information to anybody else. Once this phase has been gone through, the lead manager will produce a term sheet, just like the term sheet in a syndicated loan, and on the basis of that, the issuer will award a mandate to the lead manager or co-lead managers, usually to somebody called a book runner, because it runs the book of orders. Now again, that mandate, just like in a syndicated loan, is subject to contract and final documentation. Same thing again. And you know the rules applicable to that. Rome 2, once again, as to what law controls liability for a subject to contract and final documentation document such as the mandate. Once the mandate is awarded to a chosen lead manager by an issuer to raise the bonds on the basis of the terms set out in the term sheet, meaning currency, interest rates, terms and conditions, governing law, all of that, the lead manager chosen and given the mandate will announce the fact that it has been chosen to lead a bond issue for Hyundai, for example, on ICMA screens, Reuters, Telerate, whatever. But that announcement has no pricing. It doesn't say what interest rate is going to be charged, paid on these bonds. But what would be said is the lead manager would say, we would hope that the pricing would be 50 basis points over LIBOR. You know basis points, don't you? And I happily said basis points. You know what a basis point is? So why didn't someone raise their hand and say, what the hell is a basis point? You know what a percentage is, right? 1%, 2%? Okay, can I get a yes, no, haven't got a clue? Yes, great, thank you. So each percent, 1%, is divided into 100 basis points. And in the markets, you talk about not 1/10 or 1/50th or anything like that. You talk about basis points. So 50 basis points is 0.5%. So if you say 50 basic BP over LIBOR, it means 0.5% over LIBOR. Okay. But there is in other words, at the announcement stage that it has received a mandate, it will say, I'm hoping to pay an interest rate on behalf of, not on behalf, I'm hoping that the issuer will pay an interest rate of 50 basis points above 3-year LIBOR. As soon as the mandate is announced in the markets on the screens, something else will immediately start getting off the ground. 2 sets of documents. That's the lawyer's job. First of all, there's a draft offering circular to be put together. It's called a red herring. Because in the old days, they used to have a red mark on the damn thing, and they still use a red herring when there is no document going on, it's electronic. It's still called a red herring. It's prepared by the law firms, acting on behalf of the issuer. And the second lot that's put together is draft legal documentation. The timetable for this is dependent on when the investment banks decide they need to reach the market. If their mandate is given today and the lead manager decides we need to hit the euro-denominated market by Friday, well, Friday it is, and you'll work 48 hours non-stop to produce the documents. No questions. And at the same time, an invitation goes out from the lead manager mandated to lead the issue to other banks in the marketplace, inviting them to be underwriters to the bond issue. Now, you know what an underwriter is. I mentioned it last week, but I'll remind you. Group of banks which agree with the issuer in the subscription agreement that they would sell all the bonds of the issuer to the total maximum specified. And if they fail to do that by a specified date called the closing date, the banks would buy the bonds themselves. That's the underwriting commitment. So what the lead manager would do is to invite banks to join the underwriting group and require them to specify a minimum underwriting commitment. If it's a 10 billion issue, you'd say, I need a minimum underwriting commitment of $500 million, $500 million, or something to that effect. Okay? That'll be set out. Now, ICMA actually requires that to be set out in the invitation that goes out, the electronic invitation asking people whether they like to join the underwriting syndicate. Soon after, there's a launch announcement, which contains more details, including pricing, meaning what is the interest rate payable on the bonds, what is the maturity date of the bonds, and who's the issuer. All those details will be announced. It's called the launch announcement on ICMA screens, Reuters, Telerate, Bloomberg, whoever they are. And it'll run something like 10-year, $5 billion bonds, Fiat or Mitsubishi or ExxonMobil or Kazakhmys, whoever the issuer is going to be, due 2035, meaning maturity date 2035. The interest rate that is to be paid on the bonds is announced at the same time, usually. It can be delayed by a few hours, but no more, but it's announced the same day. Secondly, the price payable for the bonds is announced. Now here you've got to deal with a concept, a commercial concept. Like I said earlier to one of your colleagues, a bond has 3 prices. The price at which it is issued, that's the issue price. That's what's announced on launch date. A bond with a redemption price, i.e. a face value of 100, i.e. that's the amount you will get on maturity date of the bond, face value, 100, $5,000 or 100%. That's the redemption price or the face value. That's not the same as issue price. An investment bank, which is a lead manager, may price the bonds at 101% or 103% of face value. That's the issue price. So you want the bonds, a $5,000 bond, you'd pay 103% of the $5,000 face value. Or, if it's not that popular, it could be 99% of face value. It doesn't matter. There is a price, which is the issue price. And that's also announced on launch date. Once those items are announced on Reuters screens, or Telerate screens, or whatever the screens you're doing, something called the order book is opened by the lead manager. And because it runs the order book, it controls it, it's called the book runner in market jargon. So the lead manager is now operating as book runner. And what it does is that it is asking, when the order book is opened, for financial institutions, including those underwriters whom they've invited to join the underwriting group, to indicate what is their interest in buying bonds that have been announced. How much? How many millions of dollars of bonds do you want to buy? Now, inevitably, an investment bank doesn't bring a bond issue to the market unless it's absolutely sure that it'll sell out, and it usually does. The order book, in practice, is sold out within the hour because there is so much demand for the kind of issuer which comes to the market, and investment banks are careful whom they bring to the market. This system is called the pot system, and I'm going to tell you what this pot means. It's a meaningless phrase. The pot system envisages that when the order book is announced, that people are taking orders for these bonds, that the underwriting banks who've joined the underwriting group at the invitation of the lead manager will take a number of bonds, and what they can't sell out there, they will return to the pot. Old English phrase. Thus, this is called a pot system. But that's not how it operates anymore, because the pot system means that the lead manager, the book runner, now invites everybody to place orders for these bonds. And usually, in practice, the order book is sold out within hours. But ICMA recommendation rule 5.10 requires that the order book remains open at least for 1 hour. And so it is. Variation on the theme. If it's a sovereign state, and it's an extremely highly rated sovereign state, you're looking at the Swedens of the world, you don't go through the pot system. The lead manager would usually run what is called an auction. It will simply not have a price, but ask people to bid for the bonds that are being offered. Sovereign state of Sweden, what are my bids? So we will say 101% over, 102% over, meaning above the face value. So depending on the level of the bids, say there's sufficient number of bids at 103% of face value, the issuer, the lead manager will say, right, we're only selling to those who are bidding at 103% at the auction. So that is an alternative method to the pot system in the case of an extremely highly rated sovereign issuer. Next stage. Once this process is done, the lead manager then allots amounts of underwriting. Now this is very important to remember what we are talking about. It's the underwriting commitments which are allotted. How much the lead manager says you, Bank X, must underwrite in relation to this bond issue. And of course, it's a confirmation to people called managers, managing underwriters, of how much has been allotted or allocated to them by way of their underwriting commitment. Now remember, if the order book is full, the bonds have already been sold. They're not firm sales, but they are agreed sales, subject to documentation. But this is separate. It's a confirmation to the managers of their allotments or allocations in relation to underwriting commitments. How much are they allowed? How much are they being given by way of underwriting? All of that is to be found in those ICMA rules 8.1 onwards to 8.10, set out what's required, and what is to be found in the confirmation to managers, or CTM as it's called, is once again set out in the ICMA recommendations. Okay, that's stage where you now got the orders, you got the allocation of who's going to underwrite how much in relation to the bond issue, and then you come to the next stage of the bond issue process, and this is once again legal territory. Remember that red herring that was being drafted by the lawyers? It's put into essentially final form, and no law firm will ever allow this to be called anything else other than a draft offering circular, but it is in final form. That draft offering circular is then submitted as what is called a preliminary prospectus. That's regulatory language, a preliminary prospectus to the stock exchange on which the bonds are to be listed. Why? For approval by the stock exchange that it complies with stock exchange and other applicable regulatory law. From that point onwards, the draft offering circular has been submitted to the stock exchange, and until closing date, something happens in the markets. It's called stabilization. Am I going to have time to explain stabilization to you? I guess I can do it very shortly and very briefly, because I've got to come right back to it because it's heavily regulated. This is called stabilization of the gray markets. Why are we calling it a gray market? Because it's neither black nor white, but it is also the fact that the bonds have not yet been issued. The bonds are issued on closing date. Okay? But once the markets know this bit, who's the issuer, what's the currency, how much, what is the interest rate, and what is the pricing of the bonds, guess what happens? Gray market trading begins. Dealers in the marketplace will start buying and selling these unissued bonds, which they don't even have. That's easy. Except that if dealers and financial institutions in the markets take the view that the lead manager has mispriced the issue. And that means either the interest rate is off by a few basis points, just a few basis points, not percentages, a few basis points, or that the actual price of the bond at 103.5% is too high. What they will do is grey market trading, which involves something called short selling. What's short selling? I'm a dealer. I'm not in the underwriting group. I got nothing to do with the bond issue, but I look at the pricing and I think, idiots, they've got it wrong. My rocket scientists tell me this is totally wrong. It's priced wrong. So what do? I go out and sell hundreds of millions of bonds to anybody who wants to buy in the market. Not at 103%, which is the face value of the bond, but at 101.5%. Now, why am I doing that? Because if I'm right, I'm selling at 101.5 in the grey markets, and I'm expecting the price of the bonds will start falling in the markets from 103 issue price announced to 100. Maybe even 99.5 or 99 if I'm really lucky. And if that is correct, you know what I do when it reaches 99? I buy in the grey market at 99 and satisfy the sales I made at 101. Guess what I've done? I made a 2% profit on $500 million of bonds sold. It's called short selling. You get burnt. But this is why there are mathematicians working all this out, not lawyers. This is the mathematics that makes millions in days, months, not months, days, weeks, hours. Because if they get the pricing wrong, there's short selling. And if the short sellers are right, market price will continue falling and the short sellers buy and satisfy their sales. It's called short, they're called short sellers because they don't have the bonds which they're selling. Now, that's disastrous for the issuer and the lead manager because the short sellers have pushed the price of the bond from 103 down to 99 if they're successful. Therefore, the lead manager will then use countermeasures called stabilization to stop the bond price falling, not only that, to push it back up and, in market terms, burn the short sellers, kill them, in other words. It's called stabilization. Now, stabilization is an extremely complex process, and as a lawyer, we know very little about it, because if we knew, we'd be making millions rather than what we make. But stabilization essentially involves buying and selling these securities which have not been issued, taking up what are called long positions or short positions as the lead manager decides, not lead manager, it's rocket scientists decide, using derivatives and options to control how many bonds are going to be available in the market and make known to the market how much demand there is via derivatives, which the lead managers, what are called friendly dealers, will go out and put into the markets. That's stabilization. The problem with stabilization is that it essentially manipulates the price of the bonds in the marketplace. Now, stabilization occurs in share issues, bond issues, any kind of securities issue, engaged in by powerful investment banks to control the price at which the bonds are going to be sold. And usually they are successful in pushing that price back up, way up to 103.5, which was the issue price. Usually they are quite successful. If they're not, short sellers have made millions and the lead manager loses. If they win, short sellers get killed, lead manager achieves its objectives. That's the game. Now, where do we fit in? We don't get involved in stabilization, but we are involved in regulating, as usual, regulating stabilization. Stabilization is regulated both under the market abuse regulation of the EU, 2014 MAR 2014, and Regulation M of the US, both of which we'll look at in detail later. For the moment, that's all you need to know. There is something called grey market trading, which involves buying and selling of securities by short sellers and countermeasures being taken by the lead manager to stabilize the price of the securities involving this thing called stabilizing mechanisms. We'll come to how it works and what's the regulation in a short while. So we're now coming up to closing date. What happens on closing date? Well, before closing date, something else is going to happen. You remember the draft offering circular is now with the stock exchange, and they're looking at it to see whether it complies with all the relevant rules. The lawyers have all drafted all the documentation that needs to be used in relation to the bond issue. They've got to be signed. In particular, this thing called the subscription agreement. That's what triggers the legal obligations of the lead manager and the underwriting banks in relation to the issue and the bonds. So here are the documents which are signed on, it's called the signing date. The subscription agreement, which sets out the rights and obligations of the issuer vis-a-vis the lead manager and the underwriting banks. Secondly, an agreement between managers to which the issuer is not a party, but it's, as the name implies, an agreement between the managing underwriters. I'm going to take you through these documents shortly, but just to tell you what they are. And thirdly, most important one, the prospectus is signed by the directors of the issuer, if it's a corporate, central bank, if it's a sovereign state, in order for the bond issue to proceed to the next stage. Now, ICMA recommendations require that the documents should be sent to the managers 2 days prior to signing. Doesn't happen. Sometimes it's sent on the day, and people just have to run through it, read as much as fast as they can, and agree or not to agree as the case might be. But the ICMA recommendation is they must be sent 2 days before. Complied with sometimes, but not always, in a pretty time-sensitive issue where you've got to reach the market within 48 hours. Okay, so that's the signing date. And then after signing date comes closing date. Now, mind you, during this period, remember, stabilization is going on. You haven't reached closing date, so there's trading activity in the gray markets going on. On closing date, i.e., that is the date on which the funds have to be delivered to the issuer. If it's a $2 billion issue, then $2 billion have to be delivered by the lead manager to the issuer, less, of course, the commissions payable to the lead manager and the underwriters. So the funds have to be delivered by the lead manager to the issuer. Now, where does the lead manager get its funds from? Well, obviously, financial institutions and underwriters who bought, remember the pot system, under the pot system, because they would have transferred the funds to the lead manager, and the lead manager will then transfer the full amount to the issuer, assuming, of course, the bond issue is a success. Same time, when the funds are delivered, the issuer must deliver the global bond, signed and delivered to the ICSD by the issuer. The other thing that happens is that the prospectus submitted in draft form to the stock exchange is confirmed by the stock exchange as being in compliance with regulatory requirements, and thus the bonds are admitted to listing on the stock exchange when the prospectus is confirmed by the stock exchange as being in compliance with the regulations applicable. And that means that the bonds are now listed on that stock exchange on closing date. Two other documents are signed. One is something called a trust deed, or if not, if a trust deed is not being used, a fiscal agency agreement. And the second set of documents are things called paying agency agreements, which is simply that a bank says, yes, I'll agree to transfer funds from the issuer to the investors, and that's nothing that I'm going to talk to you about. But most importantly, closing date requires the issuer to submit in final form conditions precedent contained and set out in the subscription agreement. Remember, subscription agreement between the issuer, the lead manager, and the underwriters. That sets out all of the conditions precedent which must be satisfied in order for the bond issue to be finalized, funds to be transferred, and the global bond to be delivered. Until the conditions precedent are satisfied, these two things don't happen. This is pretty much like a syndicated loan. The conditions precedent have first to be satisfied. Now, in addition to all the things that you know are conditions precedent, constitutional documents, all that stuff that you find in a syndicated loan agreement, you will have other documents contained in relation to a bond issue, which includes things like auditors' comfort letters saying, yes, we've looked at the accounts of the issue and we are comfortable that they represent a true and fair view of the issuer's financial position. Then a director's responsibility letter where the directors of the issuer, if it's a corporate or the central bank, issues a responsibility letter saying, we take responsibility for all the information contained in the prospectus. And that's the end of the final process leading to the issue of the permanent global bond against funds from the issuer. But that's not the end of the process of an international bond issue. There could be a final stage, and there usually is, due to United States securities laws. U.S. securities laws requires, sorry, I shouldn't say U.S. securities laws, U.S. securities laws and U.S. tax laws, requires only the issue of an exchange of a temporary global bond for funds on closing date, not a permanent global bond. And it remains temporary for 40 days until the temporary global bond can be exchanged for a permanent global bond as required by U.S. securities laws. That's called a lockup period. The bonds are locked up. And, importantly, during that lockup period, no sales can be made to persons defined as U.S. persons under U.S. regulatory law. And the international clearance systems at the end of the 40-day period must certify that all bonds held in their clearance system are held in the language of the United States securities laws in non-U.S. beneficial ownership. Note the words beneficial ownership. That the beneficial owners of the securities credited to the ICSD accounts are not U.S. persons. Now, there's a definition of who is a U.S. person in United States securities law, which we will come to, and as you might have guessed, it does not include Goldman Sachs. Goldman Sachs can buy and sell whatever it wants, and so can U.S. insurance companies, so can U.S. banks, so can U.S. dealers, and therefore this one saying ICSD must certify non-U.S. beneficial ownership doesn't actually use purchases by Goldman's or U.S. insurance companies or U.S. fund managers and a whole pile of other people. We'll come to that later. But the point I'm making at this point is that there's an exchange of the temporary global bond for cash or funds on closing date, if U.S. securities laws require, and at the end of 40 days, the temporary global bond is exchanged for the permanent. That's the process that you'd go through. But remember the laws and regulations that affect the various stages in the process. I know, they're not going to be easy, but we'll walk through it as we go along. I think we don't have any more time, so what I'm going to tell you is what I'm going to cover next time round. I'm going to get into the documentation of the bond issue next semester. But please, when you come in and I say stabilization, short selling, closing date, you're not going to look up with that look of what is he talking about. Try and go through this thing when you come back. But in the meantime, those of you who celebrate Christmas have a great and enjoyable Christmas, and the rest of you guys have a very enjoyable holiday break, wherever you're doing, or wherever you're going. And I'll see you back in January, okay? Right, done. See, I told you that it's going to get harder and harder and harder. That's what I'm saying. It's a building block approach. Slowly build up the house. to a skyscraper. Hey, you get there. I mean, hey, we've got the seminars to help you out. Oh, this list. How many people are on that list? Just four. Oh, I'm sorry.
I'll just
Okay.
I send you the
Sure.
first seminar, all second seminar, what I've done with marks, and I'll
Okay.
take you to the day with
Where are you going for your holiday? Where else?
Yeah.
Nice, is it? But it's really, really cold now, right? No? Not.
Maybe a bit less.
Is your flat not very warm?
I might go to it, yeah, but when I go
It's worse.
like this one, it's really cold.
I've got to go do a seminar. Sorry?